My name is Iris Chu, and I'm director of the UCL Center for Ethics and Law. With me today are two very eminent speakers from Malta. Malta is a very interesting jurisdiction when it comes to crypto asset regulation because it's one of the first jurisdictions in the world to have enacted regulatory frameworks for blockchain-based organizations, as well as the virtual financial assets offering regime. And so I'm very curious as to how things are working in Malta, as well as how the passage of the EU's markets in crypto assets regulation affects the implementation of regulatory frameworks in Malta. So we're very privileged today to have two very eminent speakers, one of whom is both a regulator and a very respected academic in Malta with us today. So the order of proceedings today is as follows. We will have our speakers each take 15 minutes on the floor. Professor Christopher Buttigieg will go first, followed by Dr. Jonathan Galea. And then we'll have a Q&A session. And we encourage members of the audience at any point in time to submit your questions through the Q&A function. And I'll be moderating the Q&A session after our speakers have spoken. And depending on the questions that we receive, we'll try to have the speakers fully address them as far as is possible. So let me now introduce our speakers to you. First, Professor Christopher Buttigieg has 23 years of experience as a financial regulator. He's now the Chief Officer responsible for Malta's Financial Services Authority Supervision Directorate, and he also holds position as Chair of the Authority's Regulatory Committee and the AML Committee. He's also appointed in leading positions to the European Securities and Markets Authority and the European Banking Authority. Professor Buttigieg is also Associate Professor in the Banking and Finance Department of the University of Malta. So we're very privileged here today to hear from both a regulator and an academic. Following on, Dr. Jonathan Galea is a lawyer with extensive experience with the crypto industry. He's now CEO or founder of BCAS, which is a crypto regulatory consultancy firm. He's also a visiting lecturer at the University of Malta, and therefore comes with the benefit of practical experience, and academic perspectives. So we are very privileged today to have our two speakers, and without further ado, let me now give the floor to Christopher.
Thank you very much, Professor Shu. I'm very pleased to be here, and I really like to thank you for this kind invitation. The regulation of crypto assets in Malta is a project that has been ongoing for the past 7 years. We're always very delighted to explain what we've done and how things have developed over the past 7 years. You have given me a challenging task, I must say, because I have to go through 7 years and 15 minutes, but I'll do my best to keep to the time you've set for my part of today's session. It all started in 2017 when the government of Malta declared that it wanted to set another pillar for the economy based on technology, particularly DLT technology. There was a lot of marketing at the time from the industry to attract companies which were operating on DLT in Malta. And we saw at the time a lot of interest and operators coming here and registering their companies here to, amongst other things, offer crypto assets and crypto asset services to investors. As a result, the Board of Governors of the MFSA is the single regulator for financial services in Malta, responsible for prudential and conduct regulation and supervision. There is a separate AML CFT supervisor, which is the Financial Intelligence Analysis Unit, but we act as agents of the FIAU in the context of AML CFT supervision. But at the time, the MFSA Board of Governors decided that it was important that if this industry is to grow, it should grow in a regulated environment. And as a result, it advised the government that there should be a regulatory framework which regulates crypto asset service providers and issuers of crypto assets. We issued our first consultation on our proposed approach on the 30th November 2017. There were outlined what our views were at the time in relation to the regulation of this area. And we identified three main concerns, or rather risks: the investor protection risks, particularly the risk of fraud in this field, the money laundering risks, and also the cyber risks. And we started working on creating a framework which would address these three levels of risks. In addition, we started having meetings with all the operators here in Malta. And one of the things that came to our attention was that the governance and the compliance culture of these entities was rather weak. They did not have the compliance culture that existed in the traditional financial services field. In addition, during this period, ESMA, which is the European Securities and Markets Authority, had made a clear declaration that what is a financial instrument should be treated as such, and therefore all crypto assets which had the features of a financial instrument should be treated as financial instruments and regulated under the traditional financial services European framework, which would allow passporting and which would allow the provision of cross-border services within the internal market. So as a result of all this, we started working on a framework. The framework had to address the risks, but had to also address the impact, the possible impact of these crypto assets being treated as either financial instruments or assets falling under a national piece of legislation, which was and still is the Virtual Financial Assets Act. So we worked on and introduced what we refer to as the financial instrument test. So it's a test which the issuers of crypto assets need to undertake in order to determine whether the crypto asset is a financial instrument, or otherwise whether it will fall under the Virtual Financial Assets Act. We also worked on the Virtual Financial Assets Act. The Act regulates issuers of virtual financial assets, what we refer to as virtual financial asset service providers, virtual asset service providers, which under the MiCA are referred to as CASPs, and also VFA agents, which is something which is very local, it won't be found under MiCA. The idea of VFA agents was, and recently we had to remove this in view of MiCA, but was that of ensuring that the crypto asset service providers and the issuers are provided with proper compliance support. And in order to do so, we created this framework for professionals like accountants, lawyers, and economists, which would require them to register with the MFSA and undertake a competence assessment, which would allow us to understand whether they are competent to provide services in this field. The VFA agent had to submit applications on behalf of the issuers and the VASPs to the MFSA, and also provide them with ongoing support with respect to their compliance with the regulatory framework. Again, this to address the risks that we had identified in terms of the compliance culture and governance within these entities. The Virtual Financial Assets Act took from the high-level principles of MiFID, the Markets in Financial Instruments Directive, the Prospectus Directive, at the time, which eventually became prospectus regulation, the Market Abuse Directive, and also the Transparency Directive. So we took from these EU pieces of legislation what we thought was relevant to this field, particularly because we had made a decision to treat crypto assets, all crypto assets, as an asset class for investment purposes. At the time, we did not treat these assets as a means of payment, but as an asset class for investment purposes. And we had done that especially in view of the fact that the ECB had declared in no uncertain terms that the euro is the means of payment in Europe, and we wanted to avoid any misconceptions in relation to our framework with respect to virtual assets. Having said that, given that crypto assets could have qualified as e-money in certain instances, we allowed, or at least our framework would have allowed, prior to MiCA, the treatment of crypto assets if they satisfy the e-money directive as e-money, but that never materialized. We form part of the European system of financial supervision, as probably you are aware, and this was an area where there was very little risk appetite by our peers within the European supervisory authorities, but also at national level. So one of the things we did was we carried out extensive bilateral meetings with ESMA, EBA, but also with a number of national competent authorities. We explained what we were doing at the time. We got their views in order to ensure that our framework, they would be comfortable with our framework. Eventually, in November 2018, the Virtual Financial Assets Act was enacted by Parliament, and we started working very actively on practical implementation. At the time, there were around 180 companies that had registered in Malta to provide crypto asset services. Out of these 180, only 27 applied for a license. The rest either exited the jurisdiction or we took action to deregister these entities from our registry of companies. Clearly, the regulation had allowed us to filter a lot from the entities that had come to Malta originally to operate from here, and only those entities that felt that they could make it in terms of obtaining the license applied for the license. However, yet again, not all of these applicants eventually got the license. A number of them withdrew during the process or were asked to withdraw their application if we were not convinced that they would make it to the end line of the application process. One applicant was rejected. They did not accept to withdraw and they were rejected. And today, I mean, other license holders applied in the meantime. Some of them were cancelled their license or asked to withdraw their license. But today we currently have 15 license holders that are CASPs. Now, a number of challenges along the way, which I feel it's good that I mentioned. Number one, in terms of anti-money laundering, we went beyond the fifth anti-money laundering directive. At the time, we felt that given that we were granting a license, we had to go beyond registration under AML-CFT requirements, and we made all entities subject persons in terms of our AML-CFT. So whether they were CASPs, issuers, or VFA agents, they were all included as subject persons under the AML-CFT, subject to all the AML-CFT requirements. We did a national risk assessment with respect to the virtual financial asset sector. I believe we were one of the first countries to do such an assessment, which then filtered into our risk-based assessment as MFSA, but also as FIAU. We did a risk assessment of our sector. We classified each operator as either high, medium, or low, and all the operators were then subject to a risk-based supervisory engagement. It was the first time we did this. During the authorization process for a number of entities which we felt were high risk and were not meeting the bar, we actually did an inspection at their offices. They were already operating, they were under the grandfathering clause, and in order to make a decision on whether to license them or not, we carried out an inspection at their offices, and based on the outcome of that inspection, then a decision was made whether to go ahead or not. For the purpose of ongoing supervision, we, in addition to the normal supervisory tools, so the inspections, the meetings, the supervisory meetings, the thematic reviews, the desk-based reviews, we also added blockchain analysis tools in order to monitor the sector. In addition, in terms of governance arrangement, we established at the time, not necessarily only because of the VFA development, but it happened during the same period, we established a number of new functions which contributed a lot to the supervision of the sector. Number one, we established a fintech function, which is responsible for virtual financial assets supervision, but not only. Now today also for payments, we integrated payment supervision together with virtual financial assets, given they're both very much fintech based. We also established a due diligence function to carry out all the probity checks, initial and ongoing, on individuals involved in our financial services sector. And we also established a financial crime compliance function for all the AML CFT supervision that needs to be carried out by the MFSA as agent of FIAU. In addition, we also established an enforcement function focusing and specializing on enforcement action. In addition, or rather finally, we established our Financial Supervisors Academy in order to train our staff and upskill our staff in virtual financial assets, but also in all other areas that we cover in terms of supervision. I come to the last part of my talk. I know perhaps I'm exceeding a bit my time, but I think it's something which the attendees will find interesting. So I've listed down some points in relation to the differences between VFA and MiCA, and which currently we are working on in order to transition our industry into MiCA. Number one, the role of the VFA agent. This has been removed. That was something which is our own idea, which that did not make it in MiCA. So that's something we removed from our framework. The regulation of payment tokens, asset reference tokens, that's something that we had not provided in our law. In our legislation, there is no passporting. Obviously, it was national law, no European framework at the time. And now with MiCA, there is passporting. Costs were subject, particularly trading platforms, exchanges, were subject to higher minimum requirements under the Virtual Financial Assets Act. We imposed at the time 730,000 as initial capital requirement. Under MiCA, it's 150,000. There's no segregation requirement under MiCA. Under the VFA, we imposed the segregation requirement whereby someone operating in the traditional financial services field had to establish a separate company for the purposes of providing virtual financial assets. We were very concerned that someone licensed both under the traditional world, where there's a passport, would be also providing at the same time, under the same platform, the VFA services. So we imposed the segregation between the operations of the traditional service providers with that providing services under the VFA. That is also removed because under MiCA there is no separation. In fact, an investment firm, a bank, can provide these services. There's no requirement for an annual systems audit, which is something we had introduced by an MDIA regulated systems auditor. This was part of our framework whereby we tried to address concerns particularly in relation to cybersecurity. And there are a number of new MiCA requirements which we need to provide for. For example, the requirement on CASPs to develop a comprehensive wind down plan, which is something which we did not provide for under the Virtual Financial Assets Act. What did we learn throughout this process? Number one, small is beautiful. It allows you to be agile and to be fast. Within a period of 1.5 years, we had our framework in place. And within a period of 2 years, we were already making the authorization process of these entities. The importance of technology and advanced supervisory tools like blockchain analysis tools in order to make sure that you're able to supervise the sector properly. The importance of coordination and cooperation with other regulators in order to maintain a level of mutual trust between us and other regulators in this field. And as I mentioned before, we did both meetings with the European supervisory authorities, but also meetings with national competent authorities in this area. Last November, we organized a number of events, but last November, we organized a very large conference. We had 600 attendees on MiCA, and we had supervisors coming from different jurisdictions for this event. And the day after, we did an event for the supervisors to share our experiences with them and to allow them to better understand what we've done. And finally, the conviction that you're doing the right thing, ultimately. I remember 2017 was a very difficult period. There was a lot of skepticism in relation to the regulation and supervision of this field. We were convinced that we were doing the right thing by regulating this area. 4 years down the line, we were proved right. The European Commission came up with its own proposal that has a lot of similarities to what we've done and what we've managed to do under the Virtual Financial Assets Act. I apologize if I took a bit longer than I should have. I hope you found my intervention interesting, and if there are any questions, please go ahead.
Thank you very much, Christopher, for your very, very insightful presentation. I know that I have questions, and I know that one is already posted in the Q&A, and I can only encourage members of the audience who want to find out how it is working in MiCA, in Malta, as well as how MiCA is being implemented, to continue to submit your questions through the Q&A function. Right, shall I now call upon Dr. Jonathan Galea to provide us with his perspective? Jonathan, please.
First of all, thank you for the invitation, Professor Chu, and also, Professor Buttigieg has done this to me before, where he eats into my available time to present on the topic, so I'm quite well used to this. So, greetings, first of all. Although I bring you tales from Malta, I actually live in London. So I'm actually located here in this wonderful city. And without further ado, I'm going to just share my screen with a presentation which has no words, some very surprising images, which I'll be explaining in turn. And I hope you can all see my screen. Yes? Fantastic. So, yes, of ducks, geese, and Swiss cheese. You may ask, well, isn't this a presentation about MiCA, about Malta's VFA framework? It very much is, and I'll be explaining each of these terms and why I'm going to use them in today's presentation. So, first of all, this lovely chap needs no introduction. It's a duck, and I'm sure you're quite familiar with let's say, the axiom, if you will, of if it looks like a duck, walks like a duck, quacks like a duck, then it must be a duck. Formally speaking, this principle is used by the legislator in the term same activity, same risk, same regulation, which is the underpinning of MiCA itself. However, I definitely have a bone to pick with this particular principle because I don't believe it applies to the world of crypto assets. Ultimately and fundamentally, we are dealing with a technology that is vastly different to what we are used to. It is permissionless and decentralized. And although it might not sound like much in the grand scheme of things, it pretty much changes everything. Which is why, when talking about crypto assets, we're not really talking about ducks, but we're talking about something that looks quite similar. But I'm sure if any of one of you has ever tried approaching a goose, it definitely does not act like a duck at all. Why is this? Let me ask a question, first of all, and I don't expect answers, but more of a rhetorical question. What is a token? Well, a token, really and truly at its most basic, is just some lines of code. No rights attached to a token, contrary to popular belief. Why? Because most tokens, excluding tokens which are financial instruments, which I'll come to shortly, they don't really grant the holder any particular right. No rights of ownership, no rights of use, really. The concept of a right doesn't really match the concept of a token, contrary to financial instruments, which by and large, most of them tend to give their holders some rights which are protected at law. So if we look at the definition of a crypto asset under MiCA, which is a representation of a value or a right, I would argue that most crypto assets are simply a representation, digital representation of a value, really, not a representation of a right. Also, further to that, for one of the very rare instances throughout the history of European legislation where matters which are substantive to financial services, payments, etc., have by and large mostly been regulated through directives, now we're facing a different instrument being used, which is a regulation, which leads us to quite a massive challenge in front of us. Due to the fact that we're talking about a novel asset class altogether, very much different to what we have seen in the past, and also we're trying to reconcile decades of legislation through directives versus a regulation, all of a sudden we're going to face very much a lot of holes in the legislation that we are about to see being applied, both due to the fact that trying to reconcile a regulation versus directives. Case in point, although financial instruments are excluded from the scope of MiCA, the list of financial instruments can vary from member state to member state. So how are we going to determine exactly which financial instruments are excluded from MiCA and which ones are ultimately perhaps not financial instruments and therefore within scope of MiCA? Although MiFID itself lays out the basic list of what are the financial instruments, ultimately, as we all know, each and every member state has the prerogative to also include its own list of financial instruments in its own nationally enacted law. And also, as I'll be explaining shortly, there are some divergences between terms that are used both in the realm of crypto assets and in financial services, which, however, mean very differently when applied in one or the other. So, in order to give you the examples, I'll kindly ask for your attention because I'm going to go quickly through 5 main examples, some of which are a bit technical, but I promise I'll explain as much as possible. And of course, we have the Q&A session. First and foremost, something that I have written extensively about, something that I have debated at length about, is the famous or infamous Article 48, Sub-Article 2 of MiCA, which states that electronic money tokens shall be deemed to be electronic money. Now, I can think of multiple reasons as to why this is incongruent as a statement and why some EMTs could not qualify as electronic money, much less qualify as funds. Ultimately, under the PSD2, electronic money do qualify as funds. So far, EMTs are not part of that definition, although the currently drafted PSD3 and the PSR look to widen the definition of funds in order to include EMTs. But why do I think that some EMTs cannot qualify as electronic money? First of all, EMTs can be issued by anyone. And although there are certain obligations imposed on those issuers who are doing an offer to the public or seeking admission to trading of EMTs, ultimately, it's only those issuers who are seeking to perform such activities which are required to be constituted as an EMI or credit institution. I mean, ultimately, God forbid that, let's say, someone, I don't know, in Switzerland, now that we're talking about Swiss cheese, issues an EMT, which ultimately is just a crypto asset which refers to the value of unofficial currency, and upon its mere issuance, unless it references the euro itself, then it's deemed to be within scope of MiCA, which is a regulated framework which applies to the EU. So first and foremost, EMTs can be issued by anyone as opposed to electronic money, which can only be issued by EMIs. Speaking of EMIs and other authorized institutions, in order to transact with electronic money, the transaction has to be handled by an authorized intermediary. Not so the case for EMTs, which can be transacted permissionlessly. Also, EMTs come in multiple forms and shapes. You can have collateralized EMTs, non-collateralized EMTs, decentralized EMTs, centralized EMTs. So trying to, let's say, capture all the different forms of EMTs within one single category, and then also to add insult to the injury, stating that, well, these are all to be regarded as electronic money, and perhaps soon in the future, once the PSD3 is promulgated, if it's going to remain in its current form, they're also treated as funds. I mean, I have yet to see how this is going to be applied in practice because I can't see it making sense in my mind at the moment. Moving on. The concept of an offer to the public under, let's say, the prospectus regulation versus MiCA itself. An offer to the public or an IPO typically must be accompanied by admission to trading, because ultimately an IPO is the event which allows a stock to be publicly traded on a stock exchange. But an offer to the public under MiCA, or rather an offer to the public generally to crypto assets, does not always need to be accompanied by admission to trading. In fact, more often than not, they tend to be two separate events. So now all of a sudden we're facing the possibility of there being, let's say, certain divergences between the concept of an offer to the public and admission to trading. Can they coexist? What happens in the case of offers to the public which go on indefinitely, such as would be the case, for instance, for continued issuances of certain crypto assets? Moving on, you may have heard about debates of market abuse, potentially including as well instances of maximal extractable value, MEV in short. And this is due to the fact that the crypto asset industry is not very bright in terms of coming up with terms, because it tends to use terms which mean something completely different in traditional financial services, such as front running. Now, front running in traditional finance denotes an element of market abuse. In fact, it is treated as being likely conducive to market abuse. But it's not the case in permissionless DLT infrastructures, where essentially front running is just a race between validators to take hold of a transaction first and include it within their own block in order to capture the value that comes out of the transaction being in the cost of gas fees. Now, ultimately, this is leading to a debate whereby certain competent authorities, including ESMA, are minded and seem to veer towards direction that MEV means that market abuse is being committed. But Again, MEV leads to the market efficiencies of decentralized blockchain infrastructures. Without MEV, we would not have decentralized finance. Another point, the concept of admission to trading versus seeking admission to trading. The reality is that crypto assets can be traded without either one of those two taking place. How? Simply through the provision of liquidity on a liquidity pool on an AMM like Uniswap. That does not constitute admission to trading as such, because you're not asking anyone for permission to trade that particular crypto asset. It is simply the provision of liquidity, which might potentially constitute dealing on an account, but let's face it, it's not typically being provided as a service. Therefore, it's going to be outside of scope of MiCA itself. So how is that going to center around, again, the potential convergence, or rather, is it going to be a gap between an offer to the public and seeking admission to trading, which never gets addressed? Last but not least, to stress this once again, a token does not give you any. Anyone telling you anything to the contrary, I challenge them to prove how a token gives you any particular right in and of itself, unless accompanied by some other contract, including potentially a white paper or documentation, which actually gives you some rights, which holds a claim against the person giving you rights in terms of the law itself. So to close off, and here I'll be stopping the sharing of the screen. How does this, of course, fall within the topic of today's presentation and lecture? The legislator has done their job. They have written the law. And despite some even perhaps members of the, let's say, the legislators themselves who keep on trying to interpret the law and say, well, we meant that and not that, unfortunately for them, now it is up to the competent authorities to apply and interpret the law. There's going to be a difference between regulation and regulators, which is why now competent authorities, including EBA and ESMA, but also national competent authorities like the Malta Authority, will be taking center stage and interpreting the most extensive effort to date in terms of regulating crypto assets. I believe that including the secondary and tertiary levels of legislation, we are close to or exceeding 1,000 pages of regulations, which I think is a very tall order to go through. And I think this also underlines the importance, more so than ever, that competent authorities become intimately familiar with the industry itself, not only at a legislative level, but also at technical level. And also, I would say that those competent authorities which can leverage that they have gathered to date stand to be leaders in this brave new era of crypto asset regulation in the EU. And I believe that I have just concluded my presentation within exactly 15 minutes. Thank you.
Thank you. Thank you, Jonathan, for your fascinating presentation. And I agree with many things that you have said, regarding gaps that we continue to find in our crypto asset regulatory regimes. I think credit has to be given to regulators for boldly carving out a bespoke regime, because we know of very large and important jurisdictions that still haven't done so. But I think there is work to be done nevertheless. Right, so moving into the Q&A session, I would encourage members of the audience to send in your questions through the Q&A function. We have one question from Roberto Andrade. From the perspective of traditional financial institutions and other reporting entities, how does Malta address the challenge presented by the fact that a large number of VA transactions and the VASPs are not located in Malta itself, or even in the EU, and therefore are not registered, within the EU or in Malta? So how would you address that, in the sense that you might be dealing with many registrants who are actually not based at all, in Malta or the EU? And is that important, to you?
Well, the operators that have a license in Malta all have a physical presence here, all have substance here. So with respect to any transactions that are taking place through these entities, FSA has visibility whenever it requires, based on a request that is made to these companies. They're all required to maintain information on the transactions carried out. They're all required to maintain information on their clients, who their clients are, and carry out the due diligence on each and every client. So there is a level of control which is exercised on all the operators which are here in Malta presently. So we haven't faced any difficulty in that regard. In fact, we carry out on-site inspections, we carry out supervisory meetings, we issue requests for information, and in all instances, we obtain the information required. Same applies for the FIAU, that again, whenever it requires information for its own supervisory purposes, again, it obtains the information required from these entities. Failing to either maintain the information or submitting the information to the regulator is considered to be a breach of the regulatory requirements, and any of the operators who are in breach of such requirements would be subject to enforcement action.
Thank you, Chris. I'm just wondering, as a follow-up, I mean, do you see with the introduction of MiCA that Malta is becoming an even more attractive place for registration of either VA offerings or the VA SPs, in anticipation of course, of MiCA becoming fully implemented by other member states? Do they value the fact that you've already had a framework in place, and do you see an increase in the volumes of applicants?
We've seen a measured increase in the sense that there aren't the hundreds of applicants coming to Malta, but there are a few that have approached us, and those few generally are entities that have a compliance culture, or at least from the meetings that we've had with them, they're entities that would appear to be of the standard that we're expecting in order to make an application. We are sending the message out very clearly that yes, as a jurisdiction, we've taken a position on crypto assets since 2017. We've had the legislation in place since 2018. We have 7 years of experience in the area, and which makes it easier for us to process applications and to supervise the sector. However, we only want serious operators to come to the jurisdiction. So that's a message that is being sent out very clearly, both by the MFSA and by the industry. And as a result, what we're expecting is that the entities that approach the MFSA, those that have already approached and those that will be approaching in the future, are those that are of the right standard to implement MiCA and to operate in this sector.
Right, thank you very much. I think there is always a bit of a dilemma between trying to regulate with credibility and not promoting, race to the bottom, as well as encouraging the innovative firms to come and having a welcoming stance. Chris, do you feel that balance has been, maturing or achieved in the way the Maltese framework is being implemented, or do you think there is a balance that we are still trying to find?
I think given the approach we've taken in the past and the approach we continue taking now, I think we've achieved that balance very well, in the sense that being one of the jurisdictions that has regulated the sector from the very beginning, we weeded out the bad apples, and we have sent probably a very clear message out there that only the operators that are serious will be allowed to operate in the jurisdiction. So yes, there is a drive by the industry to attract more operators here, and we're supportive of that drive. I mean, Malta is a financial center, and financial services is one of the pillars of our economy, and similar to the UK and other financial centers, as a regulator, we need to support the drive. However, as I've mentioned before, we're only interested in operators that are of a high standard and operators that can operate without forming a threat to the integrity of our financial system and the European financial system.
Thank you, Chris. We have a number of follow-up questions for Chris especially, but I would like to ask Jonathan a question first before getting back to Chris again. In terms of what you pointed out, such as DeFi falling through the cracks of MiCA, I am curious as to whether you think that we need to have a fundamental revision of MiCA soon in order to extend its net and to become more able to capture some of the financial-like activities that are being carried on in the crypto sphere. Do you see that as an important initiative to take place, or do you actually take the opposite view? And if so, why?
Is the question addressed to me, Iris, or to Jonathan?
No,
To Jonathan first, and then I have 2 questions reserved for you, Chris.
I leave that to Jonathan.
You can't take all the questions, Chris.
Or you can jump in.
I mean, see, so I would be prone to say that, I'm perhaps of the opposite view, in that perhaps DeFi should remain outside the scope of MiCA. But then I also ask myself, what is DeFi? Does it exist? Is there really something as decentralized as we'd like to see it? But ultimately, perhaps it's not as decentralized as it should be. And I think that is a question, and perhaps some soul searching to be done, both by the industry and the legislator as well. I think that MiCA in its current form captures most of DeFi, because most of DeFi is not decentralized, and most of DeFi is, let's say, not let's say, operating in a manner that could potentially fall out of the definition of a crypto asset service provider, a CASP. Let's not forget, because I see at times that one particular word in the definition of a CASP is often ignored, and that word is undertaking. That word is very much wide in its implications and can capture any legal or natural persons as long as they are engaging in economic activity, and also capture multiple persons, be it natural or legal, who are individually constituted and acting of their own accord, but could potentially be, let's say, operating under some decisive influence by one or more of such players. So they could be seen potentially as acting in concert and therefore captured under the definition of an undertaking. So although there's this, let's say, narrative that DeFi is excluded from MiCA, ultimately it depends on what is meant by DeFi. And I'm of the opinion that most of, let's say, the DeFi out there, if you will, is actually not excluded from MiCA. It's actually within the scope of MiCA. So any attempts to go further and try to capture what should then ultimately not be within scope of the regulation itself, then I would stop short of doing that, actually. So I guess answer your question directly, I think MiCA as is fine in terms of, let's say, regulating DeFi, which is decentralized in name only.
Right, thank you. Chris, do you want to add to this?
We've got 2 other questions, Professor Chu, and we're very limited in time, I believe. So it might be a good idea to take the other questions.
Okay, right.
With you. So there's a question from Roberto again, who's speaking about whether there is unauthorized activity taking place and how is it monitored. Well, we've got as I mentioned before, we've got an enforcement function, and there is monitoring which takes place both at the level of supervision directive and the enforcement directive, and wherever there are potential unlicensed activity taking place, there is action which is taken by our enforcement function, including issuing of warnings to the public on the potential unauthorized activity taking place by operators that claim or make or indicate that they are potentially licensed by the MFSA here in Malta. Then there's another question by Marilyn. Marilyn is asking, how do you bring CASPs which are currently operating in full compliance with the MiCA requirements, particularly given that they might be far from being MiCA compliant? Well, that is primarily their role to come in line. We are providing guidance both to our existing industry that is transitioning into MiCA, and that part of the industry will be subject to a simplified authorization process, given that they are already compliant with most of the requirements. Plus, we are carrying out supervisory work and supervisory engagement to look into the extent to which they're coming in line with MiCA. So it's not just a question of them submitting updated information, but we're also looking into practice what they are doing. In terms of the other operators out there, I think they need to very quickly, if they haven't already done so, do a gap analysis between what they currently do and what is expected by MiCA, and push through their level of compliance, or upscale their level of compliance as soon as possible. Regulators in Europe are coordinating with respect to MiCA authorizations. There's the ESMA Digital Finance Standing Committee that is doing excellent work, not only with respect to the preparation of the technical standards and the guidelines and opinions in this area, but also with respect to supervisory convergence. There's a lot of work which is taking place, and sharing of experiences between regulators. So I think it's very, very important for the industry, and this is a message we've been passing on and continue to pass on, that they do their homework and come in line, because otherwise they risk not getting authorized in this field.
Thank you, Chris, for this really very detailed answer. And I think because there is so much established advisory work out there, helping the existing financial sector comply with financial regulation, crypto asset firms should also be looking into this area in terms of getting themselves prepared for compliance under MiCA. And that MiCA, although it is a bespoke, tailor-made regime, there is still a lot of it that is based on concepts, and norms that we accept in financial regulation, whether it relates to, for example, custodial arrangements, AML. There is a lot of wisdom that is already practiced out there. I don't see any further questions coming in from the participants. And so with 2 o'clock BST approaching, I would like to draw our webinar to a close. First, let me thank Professor Buttigieg and Dr. Galia for their wonderful presentations and for giving us a wonderful insight into how things are working in Malta, as well as how MiCA is being implemented. I think this is all very useful for us in terms of drawing lessons, and the UK, especially in developing its emerging framework for crypto asset regulation. And I thank the audience for your participation, as well as for the questions that are posed. So may we all keep in touch after this, and hopefully we'll be able to continue enjoying this area of interest that we have. So without further ado, I will call the webinar to a close. Thank you all for being here.